Welcome to the Supreme Court of the United Kingdom. Today we are hearing an appeal in the case of Sutherland against Her Majesty's Advocate. I'm hearing the appeal along with four of my colleagues. I'm Lord Readley, President of the Court, and I'll briefly introduce the colleagues with whom I'm sitting. First, the Deputy President, Lord Hodge.
Good morning.
Lord Lloyd-Jones. Lord Sales.
Good morning.
And Lord Leggett.
Good morning.
This is an appeal arising from criminal proceedings in Scotland. The appellant is represented by the Dean of Faculty, Gordon Jackson, Queen's Counsel. The Crown is represented by the Solicitor General for Scotland, Alison de Rollo, Queen's Counsel. And there is also an intervention by the Director of Public Prosecutions, who is represented by Mr. Duncan Atkinson, Queen's Counsel. I'll now invite the Dean of Faculty to begin his submissions.
Thank you, my lords. This arises from an appeal under the compatibility provisions from the High Court in Edinburgh, which refused an appeal from the Sheriff Court. The issues in the appeal are very well documented and are very much in agreement, so I don't intend to take time to go back over the factual background unless that is thought to be necessary. As it happens, a great deal of the law is agreed as well. So what I'm intending to do, if I may, is to focus on what I suggest might be the fault lines, the issues that divide us, and deal as best I can by focusing on them. The first two questions are quite simple, and indeed I'm not entirely sure they're different questions at all. The first question is, has Article 8, that is the right to privacy of the European Convention, been engaged in this case at all? The second question is whether or not this applicant had in his dealings an expectation of privacy. It does seem to me, as I've said, they may just be the different sides of the same coin, but they are looked at to some degree as separate issues. I'm also conscious that if I am correct in saying that he has that expectation and that Article 8 is engaged, that of course is not the end of the matter, indeed far from it. But in my submission, it is of course a necessary first step. What I intend to do, to use as it were, my roadmap, is the submissions, the written submissions which have been lodged on behalf of this applicant. And they begin at page 471 of the papers you will have. I'm not just, of course, going to read them slavishly. That would take a very long time. But I do intend, if I may, to use that as my roadmap. Paragraph 4, which is on page 471, the basic statement is made that Article 8 is engaged on the facts of this case. Firstly, by the applicant's use of Grindr, which is a social networking app specifically for gay men and other so-called sexual minorities, and it is used to seek to form relationships in that context. And secondly, by the fact that all of his telephone communications were on a one-to-one basis. I will be coming back to that, either on Grindr or something else called WhatsApp. And because of that, he had a reasonable expectation of privacy. I appreciate immediately that the Crown's answer is extremely simple and direct, and the Crown say he was engaging in illicit criminal activity, and indeed they would say of a particularly serious kind. And therefore, because of that, the Article 8 simply is not engaged in that situation. Let me just refer to various paragraphs at this stage, laying out the background as to why sexual activity in general terms, in things like Grindr or social media, it does engage Article 8. And I begin there at paragraph 5. The Strasbourg Court has found that not all sexual activity carried out behind closed doors will necessarily fall within the scope of Article 8. Nevertheless, it has found that Article 8 to be engaged even where the activity resulted in a criminal conviction. In other words, you cannot say where you were doing this, it was criminal, and therefore you cannot get the Article 8 protection. The first case which is referred to, which I don't intend taking the court to the time we have, is Dudgeon against the United Kingdom, which is cited in that paragraph. But that, of course, has to do with homosexual behaviour in Northern Ireland, which was criminalised in that part of the United Kingdom at a much later stage than anywhere else. So someone could be doing, as it were, Grindr applications, and in Northern Ireland, as against the rest of the United Kingdom, that might introduce criminal conduct. But the court has said that in itself does not take it away from the scope of Article 8. And a number of other cases are referred to in that particular paragraph, which all say the same thing. The Strasbourg Court has made clear in paragraph 6 that the fact that the behaviour is prohibited by the criminal law is not sufficient to bring it outside the scope of private life. And that has been cited with approval in a number of cases which are referred to. More generally, the principles, the basic principles of this jurisdiction in Strasbourg were restated by the Grand Chamber of that court in Ribalda v. Spain, which is cited in paragraph 7. I don't think there's any dispute about this as far as the law is concerned. Indeed, I think the Solicitor General's submissions more or less repeat this at the beginning, but it does no harm to lay it out very briefly. Whereas the court, and this is quoted in that paragraph 7, the court reiterates the concept of private life is a broad term, not susceptible to exhaustive definition. It covers the physical and psychological integrity of a person, and it can embrace multiple aspects of the person's physical and social identity. Note, I think, that would be a matter of dispute. Paragraph 88 of that case, the concept of private life is not limited to an, quote, inner circle in which the individual may live his or her or personal life without outside interference, but encompasses the right to lead a private social life. That is, the possibility of establishing and developing relationships with others and the outside world. And again, a number of cases are quoted. There are a number of elements relevant to a consideration, this is paragraph 89, of whether a person's private life is concerned by measures effected outside a person's home or private premises, since there are occasions when people knowingly or intentionally involve themselves in activities which are or may be recorded or reported in a public manner. A person's reasonable expectations as to privacy may be significant, although not necessarily a conclusive factor in this assessment. That is why at the beginning I said, in one view, the two first questions were other sides of the same coin, because obviously an expectation of privacy is an important factor as to whether Article 8 is ever engaged at all. I go on in paragraph 8 to deal with another situation that private life that is protected by Article 8 extends beyond the inner circle of pre-existing or formally sanctioned relationship. It must allow for the possibility that an individual can approach others in order to establish and develop relationship with them. And there is the paragraph there that deals with that. There cannot, in my submission, therefore be a narrow interpretation of private life. And of course, paragraph 9 in my submission makes that point quite clearly. There are a number of elements relevant to a consideration of whether a person's private life is concerned by measures effected outside a person's home or private premises. And that, of course, repeats what has come from elsewhere. This is really summed up. The position that we adopt is really summed up in my submission, important paragraphs 10 to 13, which follow immediately on from that. The private life of an individual extends beyond the narrow circle of persons with whom that person has long-standing pre-existing relationship. Lord Roger of Elsferry explained how the Strasbourg Court has moved from understanding private life in respect of an inner circle toward the right to a certain degree, the right to establish and develop relationship with other human beings, the right to instigate new relationships, even potentially transitory ones, through dating apps and services falls within the private life of the appellant and every user of services like Grindr. As the court has recognised in another case that is there quoted, a Scottish case, the question as to whether there has been an interference with the right to respect for a person's private life will depend in each case on its own facts and circumstances. There are agreed facts in this case by the sheriff who originally dealt with this point at a debate on the original compatibility minute. But it is agreed that the account on Grindr to which the appellant responded did not at first declare it was an account of a 13-year-old boy, although the 13-year-old boy was the account in the sense that that was the pretense. That information was only provided by the decoy in response to the first indecent image sent by the appellant. When the appellant sent the first image to the account, that action formed part of his private life that is protected by Article 8. So when he began this communication, he had that protection. We submit that the private life of the appellant extended to his conversations about sexual matters with others. It didn't matter that he did not have a long-standing pre-existing relationship with the person he was thought he was communicating with, and that Article 8 was engaged. Now, having said all that, I immediately accept the Crown largely agree with all of that. At least I hope I'm right in that, the Solicitor General is shaking her head, so they don't agree with all of that. But the main argument which I thought the Crown had against what we are saying in this, and that is at paragraph that is at page 495 and at paragraph 7 of the Crown's response. And this is put very simply. However, the criminal prohibition of sexual conduct between an adult and a child does not engage Article 8, and the case of RVG is referred to. Baroness Hale of Richmond, thus Article 8 is not engaged in relation to the appellant's private life in the present case. Now, that, as I understand it, really does focus and sum up the Crown's position on this matter. The Article 8 cannot, as it were, kick off, cannot come into play because of that statement. But what I would want to do is look at that case which was dealt with in Strasbourg, and that's one of the few things I will try to put on the screen. That is the case of G versus UK, I think. Yes. I know it's at page 1499 of my volume, but I've got someone else trying to get it on the screen. That's way beyond my technical ability, I'm afraid. I want to look in particular, if I may go down in that, to paragraph 35.
Yes, we have it at the case is at page 1489 of our bundles.
Well, that's right, but I'm now at paragraph 35 of that.
Yeah, we've got that on page 1499.
Yes, that's what I've got too. All right, we're all on the same, literally, on the same page. Paragraph 35. The court notes that at the time of the events in question, the applicant was 15 years old and the complainant was 12. The applicant was convicted and sentenced on the basis that both parties had consented to sexual intercourse and that the applicant had reasonably believed the complainant to be the same age as him. In these circumstances, the court is prepared to accept that the sexual activities at issue fell within the meaning of private life. The court therefore concludes that the criminal proceedings against the applicant, which resulted in his conviction and sentence, constituted an interference by a public authority with his right to respect for private life. So that, in my submission, is a clear situation where there is criminal activity and yet there is still the protection of Article 8 for private life. Now, to that I would add two things which are important in my submission. One, perhaps less important, is that this was to do not with the communication but with actual conduct. It was actual activity rather than communication, although that may not be a very significant distinction. The real point is that all I'm dealing with here is whether the protection kicks in. I said in that case it did. Now the applicant, the appellant in that case, did not win the case, because when they moved on to all the other features, the justification for the interference, the legality of interference, etc., then in the circumstances the Strasbourg court held that was absolutely okay. So the fact that there has been an interference with the private life, that is an Article 8 situation, is, as I've said at the very beginning, not the end of the matter. It is just the starting point. But what I say that case tells us, and what the authorities I've been looking at tells us, is that there's no basis for the statement, if you're engaged in criminal conduct, even rather abhorrent criminal conduct, you lose the Section 8 right. It may not do you a lot of good to have it. I'm sorry, I see someone's hand in the air.
What do you say about the rather obvious looking distinction that your client, unlike the applicant in the case we're looking at, did not reasonably believe the complainant to be the same age as him? At least he didn't after he got the response to his first communication.
I would say to that does not actually make a difference. Of course, initially, he did not realise that. The real...
Can I just interrupt, in fact, is there any finding to that effect? Because we know that the profile was created using photographs of a 13-year-old boy.
I thought it was an agreed fact that at first he did not... I still don't take the view that that is crucial to it, answering both my Lord in the Chair and Lord Legate, for the reason, the only question I'm looking at here is whether or not you are engaged in private activity which has an Article 8 protection. The answer might be, for the reasons which is pointed out, that you're going to lose that protection. In effect, you're still not going to win the argument. But I say that the initial point, which we're only answering at this point, is, does the protection of Article 8 apply? Is it an interference with your private life? And it may turn out to be a justified interference. It may turn out to be an interference which is according to law. It may be proportionate. Call it everything you want. But my starting point is none of that affects the fact that you're in Article 8 territory. You cannot just say Article 8 does not apply here at all. What I go on to after that is, of course, the idea of the reasonable expectation of privacy, which I see is very connected. I'm sorry, I was referring to somebody else in the room. My apologies. The reasonable expectation of privacy begins at paragraph 14 of our submission. What the High Court's Justiciary said in its opinion was that even if the correspondence or the communication between the appellant and the decoy fell within the broad ambit of Article 8, which I say it does, the effect of the lack of any long-standing pre-existing relationship between these with whom they thought there were communication did not give rise to any reasonable expectation of privacy. Quite bluntly, my position is that they're wrong in that simple conclusion. The question of whether there was a reasonable expectation of privacy must turn not just on the nature of the relationship or communication, but also the place where the communication took place. It's been agreed that the communication referred to in evidence were between the appellant and the decoy alone, and the messages sent in WhatsApp were secured with end-to-end encryption. If I may say so, it perhaps seems the case that in the lower court, their lordships appear to have misunderstood how WhatsApp and Grindr work. None of these communications took place in so-called chat rooms. There is reference to chat rooms in that decision of the High Court, and I think perhaps in the Solicitor General's submission. But these are not chat rooms. Chat rooms, as I think, and I'm sure my lords know, are something different. They can involve multiple groups of people. By definition, a room of people chatting. This was always personal, one-to-one communication between the two users. And that technology was recently subject to a proof in the outer house of the Court of Session in the case of the Chief Constable of the Police Service of Scotland, where it was held that WhatsApp in itself gave rise to a reasonable expectation of privacy. And the key section, I mention it in paragraph 17. In conclusion, it appeared to me that having regard only to the characteristics of WhatsApp, an ordinary member of the public using such could have a reasonable expectation of privacy. The other thing I would say about Grindr, which I'm reminded, is, of course, that while the profile might have suggested he was younger, you have a reasonable expectation that anyone using Grindr is of full age, because you're not allowed, in inverted commas, to use it unless you are 18. So I accept that after the first correspondence, the person, the decoy, then said they were under 18. But you cannot simply assume that until that is said, because Grindr does not operate in that way. I go on at paragraph 18. As has been observed already in this case and argument, the protection of Article 8 must extend to beyond the inner circle of pre-existing or formally sanctioned relationships. It must allow for the possibility that an individual can approach others in order to establish and develop relationship with them. In his analysis, and I refer to another case, it is accepted that the sexuality of an individual and the zone of interaction between himself and others form part of the cluster of values which lie at the core of the rights protected by Article 8. And I'm back to the main point, you don't lose that because it's involving criminal activity. The initial stage of the communication, as I've already said, I think to Lord Leggett, between the appellant and the decoy took place in Grindr, where sexuality of users is very much the whole point of it. The decoy announced eventually, or after some correspondence, wow, I quote, "I'm only 13, by the way." I do not accept that from a profile he would have known the user was a child. Profiles, people put on all kinds of pictures. You cannot tell. Grindr is something you have to be 18 to use it. I think it would be common knowledge that in profiles on Facebook and all kinds of these places, people put pictures in profiles which are not necessarily theirs, are not necessarily accurate. You cannot look at a profile picture and form a view as you are looking at the actual person, because very often that is not the case. Or indeed what is said in the profile. The bottom line is we're dealing here with somewhere you have to be 18 to use it. So I accept fully that very quickly it became clear this was a 13-year-old, but I don't accept that that would arise purely from the profile before the person said that.
Can I just intervene? In fact, I mean, we're not sitting, obviously, as you know, we're not sitting as a criminal appeal court.
No.
were confined to the compatibility issue. And I'm not sure that it's critical to that issue. Well, that for the purpose of determining that issue, it's really useful to focus on one particular communication. The indictment covered a period of some weeks and a number of communications, didn't it?
I totally accept that. I was only answering the point that he would have known from the beginning. I was simply dealing with the suggestion made to me that from the very first he would have known that. And I'm saying that's not necessarily right. But I do accept my Lord and the Chair's point that that's not the real issue. The real issue is whether or not someone in that situation has an Article 8 protection and has any right to a reasonable expectation of privacy. I accept entirely what my Lord and the Chair says, and I was only answering that for the limited purpose of the question that Lord Leggett was posing to me. The initial conduct of decoy was covert, in that his relationship with the appellant was conducted in a manner that was calculated to ensure that the appellant was initially unaware of his purpose. At the end of its opinion, in paragraph 48, the High Court assert that the appellant was fully participating in the communications and were aware of that they were reaching the intended recipients. Now, to that extent, that is correct. But initially, at least, it was the case as I have outlined. The decoy established a personal relationship with the appellant by means of a false persona on Grindr and used that relationship to obtain information about the appellant and disclose that information to the police and then to Respondent. I come back to the basic point that when someone goes on to that system, Grindr, they have got an expectation of privacy. That privacy, we come later on to whether that can be interfered with, the role of the public authority and interfering with it. But I keep saying that at this stage, I'm only dealing with the very initial point of whether that is engaged or not. The Crown response, I was going to say is broadly in agreement, but I better not, because the Solicitor General shook her head the last time I tried that. Begins at page 495 of what they are saying, and they deal with the reasonable expectation of privacy there, and it's worthwhile in my submission looking at. I jumped, I think, to paragraph 14 on page 497 rather than read right through. The appellant contends that his private life extends to his conversations about sexual matters with others, and that the sending of sexual messages and sexual written communications by the appellant to the decoy was about a topic that necessarily engages Article 8. Well, of course, that's right, that is my position. While that may be so as regards some, if not most, sexual communications, it is not correct in respect of the type of communications involved in the present case. The question of whether Article 8 is engaged by the types of communications involved in this appeal can be answered by an examination of the circumstances of the sending and of the nature of those sexual messages and sexual conversations, and in particular, whether in those circumstances the appellant had a reasonable expectation of privacy. Now, that is where I say again, that is jumping ahead. That is moving to the next stage of the argument. Even if you have the expectation, then so what, it might not do you much good in certain circumstances. The appellant contends, say the Crown, that the High Court erred in concluding the appellant, indeed any user of Grindr and WhatsApp discussing sexual matters on a one-to-one basis does not have a reasonable expectation of privacy when doing so. That's right, that is precisely what we disagree with. The court, in its judgment, found that given the lack of any long-standing pre-existing relationship between the appellant and those with whom they thought they were communicating, they had no reasonable expectation that these communications remained confidential or private. The court will, of course, know that there were two parties in the case before the High Court, which is why it is in a plural. One party is not obviously appearing in this situation. Where I take disagreement is the appellants voluntarily entered into the chat rooms and subsequently participated in WhatsApp with persons whom they thought were children for sexual purposes. In due course, that's right. The paedophile hunter groups were targeting particular apps used by persons for sexual purposes in circumstances in which it seems to have been known that some persons using those apps do target or group those underage. The criminal activity had already been carried out. Well, of course, that's right. Looked at in what I will call later a simplistic sense. The appellant corresponded with a person who he never met before. He sent an explicit sexual image. He said he was a 13-year-old child, etc., and I accept that. Where I do not accept is the idea that somehow, and this is the main point of the Crown submission, which is in paragraph 16, and this is where I say a mistake is made. The online communications have at page 498 over the following 13 days constituted prima facie evidence of serious crime. Maybe so. No person in the position of the appellant could have a reasonable expectation that the recipient of their messages would keep them private. It is entirely foreseeable that the recipient of such messages would tell a parent or other responsible adult about them and the messages. Now, I say there is a gap in the logic of that. It jumps from reasonable expectation to something which is foreseeable. These are important distinctions in my submission. Anyone could have a reasonable expectation that they are entitled to privacy. That does not mean it would not be foreseeable that someone would break that. The fact that it is foreseeable does not take away from the legal right to an expectation of privacy. Of course, that was foreseeable. It is argued again, it is foreseeable that receipt by police officers would lead to investigation and potential criminal proceedings against the person sending the messages, proceedings in which the messages be used as evidence against the sender. And of course, that's foreseeable. That degree, if I may put it this way, is the risk that people who use that sort of app are always taking. But we're dealing with whether in law they have an Article 8 privacy and a reasonable expectation to privacy. You cannot counter that by saying whether you have the reasonable expectation in law or not, it is foreseeable that someone will do something that takes away and undermines that expectation. So I say that when the Crown in their submission bring in foreseeability as the rebuttal to an expectation of privacy, that is not right and does not make proper legal comparison and analogy. The fact of the present appeals, paragraph 17, illustrate that the appellant was only too aware of the possibility that his communications would be shared by the child whom he believed to be the recipient. Of course, there's always that possibility. Anyone who enters into this sort of thing runs that risk. That must be common sense. That might always happen. And indeed, you can see that, as is pointed out from the Grounder chat. But none of that changes the basic situation. Although he says to the so-called child, this is a private chat and not tell anyone, the Crown said, paragraph 18, that may be said to demonstrate a wholly intelligible field discovery, which of course it does, and an associated desire for secrecy, that is right. That does not to take away the expectation of privacy as a legal expectation. And I say that is where the Crown go quite wrong on that. That, of course, is not the end of it. At paragraph 23, the Crown goes on, we go on to the whole, sorry, let me go back to my papers. That, of course, is not the end of it, and we have to go on after that, of course, to the involvement by the public authority. Let us say that, oh, I'm sorry, I didn't see you, Lord Legate, my apologies. I'm finding it hard enough to do two things at once.
I just wanted to ask, why do you say it's reasonable to expect that a child to whom you send illegally a sexual image will keep that private? It would be sensible for the law to protect that expectation, if you have it.
I didn't catch the very last bit of that, Lord Legate, I'm sorry.
It would be offensive for the law to protect such an expectation of privacy.
Well, I understand that point, but nevertheless, we'll look at how it was. I'm not saying disagreeing with that. We're then going to move on to something else. Whether you can go over that by the application of the law. What I'm going to say is we didn't. I'm not for 1 minute saying that your legal Article 8 right or the expectation you would have of privacy ends the matter. Of course it doesn't. But we go on later to look at how the law was overcome, as it were, and I use that phrase loosely, systemically, which is the main point of this. Of course, in the end of the day, the state would be entitled to behave in the way that my Lord Legate says, but I'm suggesting that that doesn't take away from the basic point. I'm trying to keep a division between the Article 8 right with the expectation of privacy and what the state can do thereafter.
I know you are, but I'm just talking about the beginning of the day, and I thought you were drawing a distinction between what was foreseeable to the appellant and what it was reasonable for him to expect. And you were suggesting, although it was foreseeable that the person he thought was a child might tell a parent or so forth, it was quite reasonable for him to expect that that would not be the case and that the law ought to treat that as a prima facie a protected right on his part, unless there's a good reason to interfere with it.
I see that, but that would suggest to me that every time there is a reasonable expectation of privacy, it's always foreseeable you will lose that. Now, this may be an extreme situation where it's a child might tell the parent, etc. But you cannot take away the legal right to Article 8 with a reasonable expectation of privacy by pointing out it is foreseeable that someone might breach that. Because in every single private situation where you have a reasonable expectation of privacy, it is foreseeable that that might be breached. So I say we'll have to keep these things separate and we'll move on to the next stage as to, yes, of course, the state has to deal with this, but it's how it does it in terms of according to law, as against just saying, well, you're losing it because it's foreseeable you might lose it. That is why we go on at paragraph 23 of our submissions to the involvement of public authorities with paedophile hunters. The Crown response to that is, of course, again, quite stark, if I may put it that way. And at page 500, they say two things about that. They say, first of all, that this is at paragraph 20, there was, first of all, no interference at all with that right. And that does not apply to communications which have already reached the addressee and are kept by him. Once they get to the destination, then you have no right to privacy. I suggest that is a difficult idea to really understand, because there must be, in my submission, common sense situations where your right to privacy exists even when matters have gone to the recipient. I take the rather perhaps childish and obvious example of love letters which one sends to someone else. Does the right to privacy of those letters simply disappear if someone comes in and takes them because they've already gone to the person you send them to? That would suggest that doesn't make sense. That at the end of the day, it cannot be simply as simple as to say, well, the person who's now got it, therefore it doesn't make any difference, the right to privacy simply disappears. More importantly, the Crown go on to no interference by a public authority. And that, I suggest, is the main focus of my argument. Assuming I'm right in the reasonable expectation and the Article 8, that, of course, is where it is the main focus of our disagreement. They say there is no interference by a public authority. And the reason I think, and I'm summarising it here, the Crown say that is, the public authority, in this case the police and eventually the prosecution, knew nothing about this until it happened. That, I think, summarises the Crown position. By the time the Crown knew about it, it was done, so the Crown cannot be in any way part of interfering with that. So that is why they say at paragraph 25, in determining whether there has been an interference by a public authority for the purposes of either Article 8.2, etc., in circumstances where the actions in question are those of a private individual, it requires to be assessed whether the state authorities to whom the acts are sought to be attributed were responsible for the inception of the scheme or made a crucial contribution towards its execution. And the Crown simply say, not us. Nothing to do with us. We didn't know this was going on. The cases which are cited are instructive in that, and that is paragraph 26. And they can be looked at, and I'm perfectly happy for the Solicitor General to look at those, as I'm sure she will in due course. But going to paragraph 27, by the time which the police were informed, the criminal activity had already been carried out. The court further noted that the question of whether what an entrapment in that case, and I pause to say I'm not arguing entrapment, that's a different matter, could be different if it was both hinted at and asserted during submission. It was demonstrated that the police or other agents of the state were in cahoots with the paedophile hunter organisation, whose members acted as the decoy. Well, I understand that, but that is where we say we disagree. There is no evidential basis for any such hint or assertion in these cases. We disagree with that. That, we say, is the whole crux of the matter. In fact, the systemic way this has been dealt with would demonstrate that that is not right. They go on to say it could be different if the decoy had been acting under the direction of the police. That is not what happened. Yes and no is what I say to that. The police were unaware of the decoy's actions until the chats had concluded and the confrontation meeting had been fixed. Maybe. At paragraph 50 of its opinion, the court again noted that there had been no involvement in the state prior to the evidence being received. That really, if I've understood it aright, sums up the Crown position. Basically, by the time we know about it, these are private individuals doing something like that. And of course, I can understand that argument basically. And that is why I come to what I consider to be the most important single word in it, that this is a systemic approach by the Crown. Had this been a one-off, then we would be getting nowhere with this argument, and I would not even be attempting it. Had someone did what the decoy did and simply said, did it, and then told the Crown about it, and the Crown went, oh, well, we've never heard of that before. That's a turn up for the books. Thank you very much for that information. This argument would not exist at all, and I fully accept that. But my approach to that, my approach to the Crown's position, the washing of the hands of responsibility, is equally simple. I say that is simplistic. I am tempted to say somewhat disingenuous, but what I do say is it simply ignores the actual reality. The actual reality does not bear that out, no matter how much it is sought to be disguised. The reality tells us something different. Now, I deal with that from page 477 to the end, and it is perhaps worthwhile going to the end where it is summed up before I come back to going through the various issues on that. And that's summed up at paragraph 66, which is on page 490. The court is therefore faced with a situation where OCAGs are either self-tasking chizzies who are operating without proper authorisation under RIPSA, or where they are repeatedly acting as the eyes and ears of Police Scotland and the respondent to avoid the need for investigative authorities to comply with the requirements of RIPSA. Therefore, the resulting interference with Article 8 is not in accordance with law, as is required by Article 8.2. In these circumstances, the use of evidence obtained by the Decoy and Groom Register Scotland amounts to an interference of the appellant's Article 8 right and is not in accordance with law and is therefore a breach. The best way for me to demonstrate that, which is basically the key of my argument, is to make very specific points. The first point is this: there are lots and lots of hunter organisations. Paragraph 23 Sheriff Scullion says, Groom Register Scotland is one of several organisations deploying similar operating methods which operate in Scotland and other parts of the United Kingdom. The police are aware that there are a number of hunter organisations operating in Scotland and across the United Kingdom, and evidence obtained from these organisations has led to a number of criminal investigations and prosecutions. Now, very fairly and properly, the Crown have supplied us with lots more information. Even up till yesterday, I think we were getting more information on that subject. But what is clear, that this is a very large-scale method of obtaining evidence for prosecution, very large scale. I'm sure the Director of Public Prosecutions has the English figures, but I have the Scottish figures. It is very large scale. For example, in the 3 years up until 19, at least 164 cases were dealt with prosecution. There are in Scotland, I think I was told yesterday, and I'll correct if I'm wrong, 110 cases in the queue, partially caused no doubt by COVID and partially caused by the case we're dealing now. This is a huge system of prosecution. So the idea that somehow it all comes to the Crown in a not surprising way, but something that they are not in cahoots with, to use the phrase that was used earlier, is something I completely disagree with. This is not a one-off. If this was a one-off, we would not be here. If this was simply a citizen doing something, we would not be here. We're here because, and I think this perhaps seemed clear in the opinion of our High Court when this appeal was heard, there is quite frankly a deal of disquiet about that, a deal of disquiet about the whole operation of vigilante groups, of hunter organisations, which in general terms do not fit nicely or kindly with the way we do things. And it is because of that disquiet, I suspect, that this matter has been referred to you, because there is a disquiet, because it is a systemic use of these organisations by the Crown, who then say, nothing to do with us, they just come to us as private citizens. And to what I simply say, aye, right, that's not quite correct. It doesn't really work the reality. The police have been given guidance on dealing with such groups. So they don't come as any surprise, and England have given similar guidance. I noticed that the DPP has also given guidance. I also noticed the Crown Office has been silent on this matter, as far as I can make out, but if I'm wrong, I'll be corrected again. But undoubtedly, the police have been given guidance, and that guidance repeats earlier guidance, which gives all kinds of warnings about dealing with these groups. And it's all very sensible, and it is there. It's in page 478. Various guidance has been. I'm sorry, something else came into my machine. My apologies. Various guidance has come in. Quick reference guide to responding to an investigating report from online vigilantes was the subject of a document in 2018. That's now been changed, I think, to take away from the word vigilante to online sexual abuse exploitation activist groups. The Crown have dropped the word vigilante for perhaps obvious reasons. So of course there's lots of guidance given. Be very careful, for example, and it's all listed in the core documents what the guidance is. Be very careful that they're not doing anything illegal. Make it clear to them they're acting off their own bat. They're not entitled to do things that they're not entitled to do legally. But the figures suggest that there's been a huge number of cases which have then been prosecuted on the basis of this information coming. I can't give you the exact percentage, but it's very high. If one takes the number of cases which are supplied to the Crown in Scotland, I use the word supplied loosely, by this system, a very large, 80–90% of them actually result in prosecutions. That means that you can have all the guidance you like. You can supply huge amounts of guidance, as is in paragraphs 25–26 of our submission. But what you have is tacit encouragement to these groups, and you can have all the guidance in the world. That doesn't change. And the tacit encouragement comes from the fact that you prosecute almost all the cases they bring you. Of course, there are obvious dangers. The Crown point out the obvious dangers, but it doesn't seem to matter. The DPP sums up this argument in his submissions at 537 at paragraph 37. And I don't take away from that. Let me just come to that very quickly. At no point in the guidance is there any suggestion of taking action by any OCAG or encouraging their activities. This is made clear. So what the Crown is saying, we don't encourage these activities. We don't ask them to do it. We show all the dangers if they do it. We point out the risks involved in getting evidence which is admissible by this basis. Oh, very well. It's like lots of things that come from government. Policies are there, but reality is different. That is all very well to say all that. And then you prosecute something like 90% of the cases they bring you. You're a hunter group, if I may put it that way. What do you take from that? You would take from that an encouragement. If they said, if the hunter groups found that there was hardly any prosecutions, then of course that might be entirely different. But hunter group will say, well, we've had all these statements made to us about be careful, etc., 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 etc. It's all been released, reams of documentation. But at the end of the day, we're pretty sure that if we carry on doing it, they'll prosecute. Now that is systemic tacit encouragement. Interestingly, as I may put it this way, on some occasions we are told the police have themselves used undercover operatives in this context. Not often, but in a small number of cases, rather than relying on hunter groups, very, very small number of cases, they have used their own undercover operatives, and they have used RIPSA, and I come to that. They have used the RIPSA requirements, and they have operated in more or less the same way. Very rarely, I may say so, because mostly by huge majority, this is left to hunter groups. An interesting question which I pose in the passing is, why do the Crown use RIPSA at all if there is no Article 8 right engaged? I suggest that is illogical. Now, maybe it's just the Crown taking a belt and braces approach, I suppose. But the Crown, if they're doing it with their own people, say it requires RIPSA authorisation. But if the Crown is right that you have no Article 8 engaged because of the sort of conduct you're engaging in, why do they do that? That would suggest, could I suggest, that the Crown realised that if it has been doing with their consent or organised by them, it does need RIPSA authorisation. Or else, I come back to the basic question, why else would they use it? What is happening here is the statutory scheme for regulating covert human intelligence sources, CHIS as they are referred to, is being systemically avoided. The Code of Conduct, I'm at paragraph 32, the Code of Conduct which is issued in Scotland about this, says that a CHIS may be self-tasking and the public authority intends to make use of that material for its own investigative purposes. In that situation, where the CHIS has been self-tasking, but it comes to the attention of the authority, and I think this applies to in England, then they should then be seeking a CHIS authorisation. It is activity of the CHIS in exploiting a relationship for a covert purpose which is ultimately authorised by RIPSA. I'm at paragraph 32. Whether or not that CHIS is asked to do so, important ones, by a public authority. It is possible, therefore, that a person will become engaged in the conduct of a CHIS without a public authority inducing, asking, or assisting the person to engage in that conduct. An authorisation should be considered, for example, where a public authority is aware that a third party is independently maintaining a relationship in order to obtain evidence of criminal activity, and the public authority intends to make use of that material for its own investigation purposes. To which the Crown will again reply, yeah, but we don't know. We don't know these things in advance. And to which I reply, that is disingenuous. That is utterly disingenuous. It avoids the reality of a systemic knowledge of what is going on. So the Code of Practices envisages how a person can become a CHIS even without the authorisation of a public authority if it is their intention to exploit a relationship for a covert purpose. It requires to be proportionate and necessary. Now, I've argued, and the Crown disagreed, that if they tried to get the authority, they wouldn't get it. But that we'll never know. I mean, that in a sense is irrelevant because they have never done that. The decoy had, in this case, was tasked by Groom Register Scotland, about paragraph 36. Had the police decided to task the decoy, they would have required to obtain authorisation as a CHIS under RIPSA. He would have required a clear of RIPSA that had the decoy been tasked by the police, authorisation would have been required. The police did that with their own operation. I've already posed the question, why did they think that was necessary at all? But the police did that with their own operations. Had they got an authorisation for this decoy to act as a CHIS, then that would have been in accordance with the law. No one would be here because that would have happened. But that authorisation might not happen because that would have very clear implications for the privacy of all users on these apps, leaving aside the people who are doing this with children. So it's not at all clear that that authorisation would ever have been granted. We go on to say that while the actions of the decoy do not amount to entrapment, and my Lord will appreciate entrapment is a very high bar, it requires certain standards, and the cases where entrapment is successful are extremely rare. I don't know about south of the border, but north of the border, they are extremely rare. But what they're doing about it is what we call, or what has been referred to as virtue testing. When you put this sort of thing out on the internet, you are virtue testing. You're not targeting a specific individual you know about. You are virtue testing. Now, my lords, I'm sure know what I mean by virtue testing, but of course, the police cannot go around a supermarket and leave £10 notes sitting, lots of £10 notes sitting on the basis that if they do that, we'll catch people picking them up and not handing them in. That's just not on. They cannot leave car doors lying open, watching to see if people will go in and steal them. That is not on. It's not, strictly speaking, entrapment, possibly. But because we do not approve of that, if we did, we'd perhaps have to expand the law of entrapment. Now, I could give, and the court will be aware of this, lots of examples of virtue testing, but it's not something which our law approves of at all. Now, that is what is happening here. The Crown know it is happening, and when this virtue testing, as I call it, produces results, they say, well, we're simply going to use them because it is very abhorrent. If it was different kind of crime, would they allow it? If it was virtue testing for minor matters, I don't know what would happen. The Crown cannot hide behind the fact that this is very bad behaviour. No one disputes that. Getting involved with children is very bad behaviour. But they cannot hide behind the fact that we'll allow it as virtue testing without proper authorisation because it is very bad behaviour. If, as I'm right, the technical aspect of Article 8 has already been taken into account. That's summarised by Lord Nichols at paragraph 38. This is by no means the only factor to be taken into account when assessing the priority of police conduct. The investigatory technique of providing an opportunity to commit a crime touches upon other sensitive areas. Of its nature, this technique is intrusive to a greater or lesser degree depending on the facts. It should not be applied in a random fashion and used for wholesale, quote, virtue testing without good reason. The greater the degree of intrusiveness, the closer will the court scrutinise the reasons for doing this. On this, proportionality is a rose to play. This is testing for a good reason, they would say. We're doing this virtue testing because we'll catch bad people. It doesn't make it an appropriate way to do things. Of course, you'll catch bad people if you do it this way. And that seems clear. And we've got 160 so far prosecutions based on the fruits of what they do. But it doesn't change the basic position that that is what you're doing. The fact it is serious, abhorrent crime does not make it a legitimate method of investigating and obtaining evidence for that criminal purpose. The only purpose, says Lord Hoffman in the next paragraph, of police participation is to obtain evidence of criminal acts which they suspect someone is about to commit or in which he is already engaged. That's not what they're doing here. They're not saying we've got somebody we know is committing criminal acts is about to. They're saying we will go into this pool, this stagnant pool if you like, and we will find people who are prepared to engage in these acts. It's not entrapment, but it is not going to someone they suspect. When they put this, as far as we're aware, with no reason to otherwise, when they put this decoy on, they were not suspecting this appellant was involved in this sort of thing. They were not targeting him. They were just saying, let us go into this stagnant pool and see what appears. And that is an entirely different thing from investigation someone. It's not asking, it's not entrapment. I understand why it's not entrapment, but it's certainly not proper investigation of what is happening. And that, in my submission, is extremely important, because people on these sites, leaving aside whether they're doing things with children or not, are entitled to privacy, not entitled to people coming in and using it in this sort of way. And that is why I venture to doubt, that if it had been sought under RIPSA for someone to go into the stagnant pool to see what they could find, not targeting a particular individual, I very much doubt if this decoy would have been given CHIS RIPSA authority to do that. And of course, there is similar codes of practice done here by those who are south of the border. I mentioned at paragraph 60 to 65 the DPP guidance on this, which does help to put it into further context. And that very much deals with the fact of being a self-tasking CHIS. This is paragraph 60, page 489. Detailed guidance is also given on the need to verifying whether the vigilante amounts to a self-tasking CHIS in terms of a RIPA. This includes the following guidance. Individuals who voluntarily provide intelligence on a frequent basis, well, this is not individuals, but it is in a sense, even though they are not specifically tasked by the police, may fall within the definition of a CHIS, where the nature of their activity, encouragement, I put the bracket in tacit, close bracket, by the police, or the provision or the frequency of provision of information hundreds of times, leads to the inference they had in fact been tasked to act in a covert manner. The Crown simply, I repeat again, cannot say, well, we didn't task them, we didn't ask them. It should be noted that it is the nature of an individual's relationship with the police, and in particular whether this is covert, rather than the police tasking an individual, which is the important factor in considering whether the person may attract a CHIS status. It's a very important situation. This individual, one might say, this particular decoy had no direct relationship with the police, but he and his organisation know, beyond a peradventure, that it is 90% certain that if they go into this pool and get something, then the police will say thank you very much and use it as evidence in the prosecution. I repeat again, it is disingenuous to go arm's length between the police and therefore the public authority and this particular vigilante group. The reference in the DPP's guidance is consistent with paragraph 226 of the Scottish Government's own code of practice. Now, it seems to be argued that, I'm not quite sure by Solicitor General, that a decoy in this organisation can never be a self-tasking CHIS. I'm not sure if the Solicitor General and the intervener are entirely in agreement on that, but no doubt that will become clear as we go along. But nevertheless, the intervener's position is Crown prosecutors are given the possibility of considering whether the person should have been regarded as a CHIS or not. the intervener gave us information, it's paragraph 62, in which he confirmed that when dealing with OCAGs, investigators and prosecutors should consider legal guidance on the Hunting Act 2004, which specifically addresses the need for independent third-party organisations to consider whether activity requires authorisation as CHIS under REPA.
Faculty, we do have to remember that our jurisdiction is confined to the Article 8 issue.
Of course.
And so anything that you're saying about REPA or RIPSA has to be tied into that, that question.
I totally accept that, my lord, but I say it is tied into that question because when one looks at the fact that REPA is not engaged, when one looks at the fact that it's not being engaged as CHISs, I say that is simply a device to get round the need to protect the Article 8.
Can I, Dean Faculty, just mention something which I don't expect you to deal with immediately, but which your team might be able to do some work on to assist you at a later stage. It's this: the compatibility issues identified by the Criminal Appeal Court, for which they gave permission, are concerned with the use of material in evidence. Now, of course, we're concerned with a particular type of material in this case, but looking at the matter more widely, as you'll be very familiar, it's extremely common in criminal trials for incriminating evidence to come from, for example, a girlfriend of the accused to whom he may have made an admission.
Yes.
And what were intended as private communications, made often in a private setting, are admitted in evidence day in, day out.
Of course.
I'm just wondering if there's been consideration by the courts of whether analytically what's going on is an interference with Article 8 rights, which is justifiable under paragraph 2, or whether Article 8 isn't engaged at all.
I'm not sure of the answer to that. As you anticipated, I don't know if that's...
No, I'm not pressing you for an answer now.
Like that. I mean, of course, I'm back here to my key word, which is, and I keep saying it over and over again, systemic. In the end of the day, that's very different from the girlfriend doing that. This is a totally different context of hunter vigilante organisations. Now, whether you could argue that, you may well be able to argue, maybe I will on another day, that the girlfriend one is a breach of Article 8, but then you would probably still lose that protection because of the remaining 8.2 according to law, etc., all the various factors that come in. And I don't doubt you wouldn't win that with the girlfriend doing that. What I'm saying here is the Article 8 is engaged. It could be lost. If this was properly investigated according to law, we would lose the protection. I don't doubt that at the end of the matter. What I say is there is a systemic method here by the Crown of getting that evidence, which actually is not according to law, because it blatantly, and I use that word, I hope deliberately, circumvents what is meant to be happening in a situation like this. And that is why the court should be extremely uneasy about that. Because even if I am wrong in some ways, by repeatedly using the information obtained covertly, the police and prosecution have encouraged these groups to operate in a manner that if a police carried it out, he or she require RIPSA authorisation as a CHIS. They've encouraged them to do something that a policeman couldn't do because it would need authorisation, although they know they're doing it dozens and dozens, indeed hundreds of times. And of course, they're encouraged to do that because they know their material will end up being used as evidence. There's a case I refer to, I don't have it here on the screen now, and I'm not going to now, at 65, a Tasmania case, to admit the evidence from a similar decoy work for a paedophile counter is giving some sort of approval to the sort of methods used by such a person. So that's a fair point, because if the court says, no, the Crown approach is right here, then it is really, and I try to use this carefully, a license for evidence to be obtained in this way. There's a very clear, of course there's a public policy, as would be pointed out earlier, in stopping this kind of behaviour, but there's a very clear public policy issue as to whether or not what is meant to be a regulated approach in our system gets got round by, as it were, I don't use the word pretense in a nasty way, but by taking the position, no, it's nothing to do with us, they're just private citizens doing it off their own back. I am back, I say, to disingenuous. Could I finally, having said it's not in accordance with law, just go back to paragraph 43 of my submission. Assuming that Article 8 is engaged, the use of communication between appellant and decoy to prosecute requires to be both in accordance with law and to be necessary in a democratic society for the prevention of disorder or crime. The issue is taken with proportionality, I just add that. The only issue in this case is whether it is in accordance with law or that limb is satisfied. And could I just turn, please, in particular to paragraph 46. Case of liberty is referred to. The domestic law must be sufficiently clear in its terms to give citizens an adequate indication as to the circumstances in which and the conditions in which public authorities are required to resort to any such measures. That is why we have RIPSA, so that there is a regulated system in place that people do know what measures the Crown can take. That means we know from RIPSA that it is, if they were using their own, as it were, undercover officer, they would comply with the RIPSA requirements. What I say, the law must be sufficiently clear to give citizens an adequate indication as to the circumstances in which public authorities are empowered to use the product of covert actions by private persons, such as the decoy used by groom registers. This requirement is not being met. The law is not sufficiently clear. If the decoy had been a CHIS authorised under RIPSA, there would have been domestic law regulating the covert work of the decoy. He was not. He was, in inverted commas, a private citizen, but private citizen of a group that enjoys the tacit or constructive encouragement of the respondent. That, I think, is ultimately the point. If the interference in the privacy of users of Grindr and similar services is to be in accordance with the law, then there must be some law, and the state cannot leave the systematic covert surveillance of its citizens to policing vigilantes. The success of the state's approach must depend on part on how the OCAG and the public at large will perceive the relationship when the use of evidence or the prosecutor is taken into account. What you cannot have is a situation where we are saying this is quite serious crime, therefore we will allow unregulated vigilante hunting, we will take the benefit of what we are getting, we will allow it to go as some kind of virtue tracing situation. All of it, if I might suggest, being justified by the abhorrence of the crime they are tackling. Let us say, and I pose this, if we had a vigilante group that disapproved of very minor crimes, you know, there are comparatively minor crimes in our calendar, would we be happy with that? If we'd sort of, the police sort of saying to vigilante groups to try and look out for people who are dropping litter or all kinds of things, and I suggest we would not be happy about it. The problem with this case is it is being clouded by the abhorrence of the sort of crime that is being possibly committed. But this court is not dealing with that. This court is dealing with, as Article 8 technically engaged as it is, for the reasons I've said, and is the interference of that, which could be according to law. I don't doubt it. It could be interfered with according to law, as happened in the case which I referred to of G against the United Kingdom. Of course, it was interfered with according to law. But if the interference is not being done according to law, if it's been done disingenuously by a deliberate systemic use of these groups in order to avoid doing it according to law, then in that case, the evidence should not be usable because of protection of Article 8. I think I'm finished, actually. I find this quite difficult to deal with, so maybe we'll take 5 minutes, because I find this process extremely tiring, extremely wearing. It's not something I'm used to, and I don't find it very comfortable, but if we take the 5 minutes now, I'll maybe confirm that's me over.
By all means, and you're not under any pressure. I mean, you've got plenty of time allocated to you that you haven't used yet. So if that's a convenient point, then we'll adjourn now and resume in about 5 minutes' time. Thank you very much. We're ready now to resume the hearing in the Supreme Court of the case of Sutherland against Her Majesty's Advocate. Dean of Faculty.
My Lord, I think that with the written submissions, which are pretty full, I have made the points I want to make. One is always tempted to use up all of one's time for the sake of doing it, but it's a temptation I've long since learned to resist. So I'm content that the point we want to make has been made, and I will go no further.
Thank you very much, Dean of Faculty. Solicitor General.
My Lords, good morning. May I say firstly that the Respondent is very grateful to the Court for agreeing to hear this appeal on an expedited basis and for putting in place, obviously, the arrangements for it to be heard remotely given the current situation. When permission was given by the High Court on 21st November last year, they characterised the determination of the compatibility issues as of general public importance in view of the prevalence of PH groups and the large number of investigations and prosecutions arising from the evidence supplied by them. And that, of course, was in part the reason for the request for expedition, as a number of cases had been adjourned and we anticipated would be adjourned in anticipation of this Court's decision on the compatibility issues, and of course in due course the High Court's decision when the case is remitted back to them. In anticipation of today's hearing, my Lords, I asked for up-to-date figures as regards those outstanding cases, so the Court would be aware. I'm told that at present, and the Dean has mentioned this, that there are approximately 110 ongoing cases at various stages of procedure in Scotland. This total comprises a number of cases reported in previous years and new cases reported in 2020. I just wanted to draw to the Court's attention that the statistics which appear in paragraph 53 of the Respondent's Statement of Case at core volume page 511 do not now appear to be quite accurate. I think the figures for 2019 appear low. This appears to have come about by a different way of checking and reconciling the information. So it was just to draw that to your Lordship's attention. It was a discrepancy that should have happened, but it was perhaps understandable given the difficulty we have in actually tracking data on these cases. My Lords, this is an appeal against a determination of 3 judges of the High Court of Justiciary against conviction of offences under sections 33 and 34 of the Sexual Offences Scotland Act 2009 and section 1 of the Protection of Children and Prevention of Sexual Offences Scotland Act 2005, all relative to the appellant's online communication and intended meeting with an individual believed by him to be a child. The individual was in fact a member of a paedophile hunter group, which I will refer to as a PH group in these submissions. who passed evidence of the appellant's communications with the adult decoy and the evidence of the meeting to the police. He was subsequently prosecuted by the respondent on indictment on the basis of that evidence relating to the communications and was convicted. Now, my lords, the issues posed by on which permission was granted by the High Court of Justiciary were actually not the two that, the particularised issues that Dean of Faculty mentioned. The first question is whether, in respect of the type of communications used by the applicants and PH groups, Article 8 rights may be interfered with by the use of evidence in a public prosecution of the applicants for a relevant offence, and we'll call that the first issue. And the second question invites consideration of the extent to which the obligation on the state to provide adequate protection for Article 8 rights is incompatible with the use by a public prosecutor of material supplied by PH groups in investigating and prosecuting crime. And you'll see that a number of particularised issues were identified by parties as arising for consideration. But I will start at the beginning and follow Dean of Faculty's lead, and if I may, deal with the first issue and the question of engagement of Article 8 in respect of the types of communications we are dealing with in this case. The terms of Article 8 are well known. Concept of private life, again, uncontroversial, although it's a broad term, not easily or exhaustively defined. Private life clearly includes sexual life, and it is the respondent's position that domestic criminal prohibition of the behaviour in question is not in and of itself sufficient to take the behaviour in question out of the scope of private life for the purposes of that provision, at least where that behaviour involves sexual activity in private between consenting adults. It is the respondent's position that criminal prohibition of sexual conduct between an adult and a child, and indeed prosecution for that offence, does not engage Article 8. There is no right to respect for such behaviour in a democratic society. And if I could take you to, just bear with me. If I first of all refer to the European Court's decision in the case of G against UK, which Dean of Faculty referred to, it's a core volume, page 1499. I don't need to take your lordships to the text. At the admissibility stage, the European Court of Human Rights was prepared to accept sexual activity in question in that case, and that was between a 15-year-old boy and a 12-year-old girl. Fell within the meaning of private life for the purposes of Article 8, in circumstances where the boy had been sentenced on the basis that both parties had consented to sexual intercourse and the boy reasonably believed the girl to be the same age as him. So quite a different factual matrix from the case in issue today. As far as when the case was before the House of Lords, there was a discussion and division, indeed, on the preliminary issue of whether Article 8 was engaged in these circumstances. And I would take you perhaps to certain comments by Baroness Hale at paragraph 54. This is core volume, page 643, or I can simply read it. The real complaint is that the defendant has been convicted of an offence bearing the label rape, and Parliament has very recently decided this is the correct label to apply in this activity. In my view, this does not engage the article rights of the defendant at all, but if it does, it is entirely justified. And it's these comments now, my lords, which I rely on. The concept of private life covers the physical and moral integrity of the person, including his or her sexual life, reference X and Y against the Netherlands. This does not mean that every sexual relationship, however brief or unsymmetrical, is worthy of respect, nor is every sexual act which a person wishes to perform. It does mean that the physical integrity of the complainant, vulnerable by reason of her age, if nothing else, was worthy of respect. The state would have been open to criticism if it did not provide her with adequate protection. This it attempts to do by a clear rule that children under 13 are incapable of giving any sort of consent to sexual activity. This does not, in my view, amount to a lack of respect for the private life of the penetrating male. So, with those words in mind, my lords, that not every sexual relationship, however brief or unsymmetrical, is worthy of respect, nor is every sexual act which a person wishes to perform, I submit, and I don't take this to be a controversial proposition, that the criminalisation of conduct prescribed by, for example, the Sexual Offences Scotland Act 2009, or the Protection of Children and Prevention of Sexual Offences Scotland Act 2005, or indeed prosecution thereunder, does not engage the article rights of the adult involved. There is a signal lack of authority from this or any other court, including Strasbourg, to opposite effect, and that's perhaps not surprising. The appellant contends that Article 8 is engaged on the facts of this case, one by the appellant's use of Grindr initially to seek to form relationships, and the right to instigate new relationships, even potentially transitory ones, through dating apps and services. That may very well be so, and such activity very well may attract the protection of Article 8, but that is not obviously what the communications involved in this case, and that is not what happened. In my submission, the protection that Article 8 extends to sexual communications and the use of Grindr to form new relationships does not extend to doing so with children or with those whom the sender believes to be a child. Now, the question... Yes, yes, Lord.
Just as a matter of analysis, I believe the very first communication the appellant made was to send a sexual image to the decoy, which then prompted the reply, "Oh, I'm only 13." Do you say that at the time he sent that image, before he got the response, "I'm 13," he had a reasonable expectation of privacy, which he then lost? Or did he not have one at all at that stage when he sent that first communication?
This brings me to a slight issue which the Dean has raised. I'm afraid, my lords, I don't subscribe to the revelation at paragraph 19 of the appellant's case that we now know that when the sexual image was sent, he didn't know that he was a 13-year-old boy. In fact, maybe it may be something or nothing, but if I could just deal with that, because it is not a matter of agreement that he did not know that he was sending that to a child. It is in the Statement of Facts and Issues, volume page 144, within the Sheriff's narrative of the facts, first of all at paragraph 2 of that, decoys create fake online personas with a general appearance of being under the age of 16. So that is part of the methods, the classic methods, which we will find reference to throughout the authorities, that profiles are created with the image of a child to lure their targets in. On Court volume page 145, my lords, paragraph 4 of the narrative from the sheriff. In the present case, the Crown witness Devine acted as a decoy. Groom Resister Scotland provided him with photographs of a boy aged approximately 13 years old, and he created an online profile on an app named Grindr. Similarly, on page 146 of the Statement on Facts and Issues, paragraph 10, Broom Resistor of Scotland had supplied the decoy with a photograph of an unidentified 13-year-old boy for use in the profile. The boy was not known to the decoy. The decoy agreed that he created the false profile as bait to draw in communications from others, to catch a paedophile and to protect children. And indeed, my lords, it is apparent from the cross-examination of the decoy at trial that he was, in fact, it was really the only area of cross-examination was the propriety of using a picture of a boy to create the profile, and some criticism of the fact that he didn't know whether the boy was an adult at the moment, or was it still a child. So, my lords, as I say, I cannot subscribe to the view that at the point of sending that first sexual image, my Lord Legate, that he did not know that he was dealing with an apparent child. Had he been an adult, had he been another user of Grindr over 18, then it may be that there would have been an expectation of privacy.
So was the issue as to the state of mind or belief of the appellant simply not explored at trial?
The appellant didn't give evidence,
No.
But that aspect of the evidence wasn't challenged as having happened. It was challenged as to the methods and the motivation and the potential safety issues around the photograph, the image of the child himself.
Thank you.
So can I just ask, what conclusion should be reached? You say that there was no expectation of privacy at the outset. Is that what you say?
Yes, at the outset, I do, my lord, for that reason. And even if that is, even if your lordships aren't prepared or proceed on the basis that it's not possible to be certain that we can draw the inference that he did know, I say that doesn't matter, given that the very first communication was sending the indecent image that we know about, to which the decoy replied, "Wow, I'm 13," and so it goes on from there. So I'm not prepared to concede that he had no reasonable belief that it was a child when he sent the first image, but equally I don't think it terribly matters in the scheme of things in relation to the reasonable expectation of privacy. And if I could just go through that, because it's important to emphasize that the test is an objective test, and given the surrounding facts and circumstances that pertained here, on no reasonable view could it be described as an objectively reasonable expectation. Again, I don't want to dwell too much on the particular facts, but they are relevant to that objective overall assessment. And the facts of the present appeal, and I've set these out for ease of reference at paragraph 17 of my submissions, my lord, about the Grindr chat, makes it only too obvious that the appellant was very well aware of the possibility that his communications would be shared by the child whom he believed to be the recipient. And I do say, and I do maintain, that while his declaration on occasions, this is a private chat, his exhortations to not tell anybody, to keep it secret, may demonstrate a wholly intelligible fear of discovery of his criminal conduct and an associated desire for secrecy, they do not, viewed objectively, equate to a reasonable expectation of privacy. And the same is true for any adult who chooses to send such a sexual communication and images electronically to a person whom they believe to be a child. My Lords, I do also, in relation to engagement of Article 8, say there has in any event been no interference in this case, and it can't be avoided that the online communications, while they may engage Article 8, that right does not apply to communications which have already reached the addressee and are kept by him. So the appellant was fully communicating, participating in the communications. He was aware they were reaching his intended recipient, and they were in due course passed to the police for the purposes of prosecuting a crime. Now, it cannot, in my respectful submission, it cannot reasonably be suggested that in reporting to the police a completed crime committed in private, by communication or otherwise, that a victim interferes with any Article 8 right on the part of the perpetrator, even where, or even particularly where, he tells her his actions are private and seeks to ensure her silence. And in practice, your Lordships will be aware that prosecutions for sexual offences, particularly those against children, are regularly and entirely properly taken on just such an evidential basis. So there is no interference of any right here as a matter of fact, and nor is there any interference by a public authority. And this will have a crossover to the second issue and such discussion as we may have about RIPSA. But it is the case that in determining whether there has been an interference by a public authority for Article 8 purposes, it is necessary to look to see whether the state authorities to whom the acts are sought to be attributed were responsible for their inception or made a crucial contribution towards their execution. And the three cases cited are there at paragraph 25 of my submissions. And I may briefly take your Lordships or go to the case of MM against the Netherlands. The passage I go to is at core volume page 179. To illustrate, really, my Lords.
Just before we look at it,
Yes.
just General, just as it were, to complete the point that Lord Leggett raised a few minutes ago, as I understand it, from looking at the Crown productions, it looks to me as though the initial image that was sent was followed almost immediately, within a minute or two, with the response, "Wow, I'm only 13, you know."
Yeah.
And then again, within a few minutes, the appellant was suggesting a meeting.
Yes.
And the indictment doesn't distinguish between the initial communication and the subsequent communications. It simply libels, alleges the attempt to send sexual communications on various occasions between the relevant dates. Yeah. So the position in relation to the initial the initiating communication doesn't actually affect anything, does it?
No, in my view, no, my lord.
Right, thank you. Sorry, I'm sorry, I took you out of. You were taking us to.
Yes, at page 179, my lord, to give an example of actions by a private individual in the investigation of crime that are imputable to the respondent state, because this is really the thrust of the appellant's argument, if in relation to the second issue. Here we have a situation where the lady who was sadly subjected to sexual advances from her husband's lawyer was helped and set up by the police to collect evidence in a criminal case. And your lordships will see at paragraph 40, the court's consideration, they considered in the present case, which, like the A against France case, is characterised by the police setting up a private individual to collect evidence in a criminal case. The court is not persuaded by the government's argument that it was ultimately the woman who was in control of events. To accept such an argument would be tantamount to allowing investigating authorities to evade their responsibilities under the Convention by the use of private agents. And so that gives perhaps a benchmark or an example of the type of situation that would constitute some evasion or avoidance of responsibilities under the Convention for covert activity.
Could I just ask for the reference again, please?
Yes, core volume 1789, my lord. That's the passage to which I've taken you.
Thank you.
Yeah.
So if, for example, the police or the prosecuting authorities were colluding with these PH groups, then a similar sort of observation could be made.
Yes, to the extent that there may have been a breach of Article 8, not necessarily that such evidence would not be in due course admissible in a criminal case. So, my lords, in brief, I think I can possibly try and encapsulate my position in relation to the first issue as to whether Article 8 is engaged at all. My answer is no, but not simply a stark response because of the nature of the conduct we're dealing with. But nevertheless, I do say that the first issue should be answered in the negative for the following reasons: that Article 8 connotes no right to respect for private life consisting of criminalised sexual activity between adults and children. And I do think that would be an absurd proposition. The right to respect for correspondence of the kind involved in the type of communications focused in this first issue, the right to respect for that correspondence ceases to be relevant once the correspondence in question has reached its intended recipient. The communications in question were in any event prima facie evidence, performative communications of serious sexual offences by an adult against a person whom he believed to be a child. In these whole circumstances, the appellant had no reasonable expectation of privacy, viewed objectively, regarding these communications. Again, no interference and none by a public authority. My Lords, turning to the second of the two issues in relation to which permission was granted by the High Court. The second issue asks whether it is incompatible with the protection of Article 8 rights for a public prosecutor to use material supplied by PH groups in investigating and prosecuting crime. And if I may follow the structure of the written submissions, but I think it becomes perhaps more important and helpful today, given the submissions by the Dean of Faculty, which have, in terms, asserted that the Crown and I think the police are acting disingenuously in a large-scale prosecution system involving the systematic and repeated receipt of evidence from PH groups. And that's not the way we do things, and it's not good. So if your Lordships will permit me, if I could just briefly touch on the domestic law duties of police and prosecutors in Scotland and of their positive obligations in this field. The High Court second issue refers to positive obligations in a very wide sense, and I will take the opportunity to address both address that in the context of this aspect of the submission. The police in Scotland, in the first place, my Lord, they operate a statutory regime which places a duty on them to prevent and detect crime, to maintain order, to protect life and property, and to take such lawful measures and make such reports to the appropriate prosecutor as may be needed to bring offenders with all due speed to justice. And that's the Police and Fire Reform Scotland Act 2012, Section 20, which you'll find in core volume, page 2043. And there is a relationship with the prosecutor in the sense that they must comply with any lawful instruction given by the appropriate prosecutor in relation to the investigation of offences, and comply with any direction given by the Lord Advocate in relation to the reporting of crime. Now, it is the case that the Police Scotland have, in recognition of the phenomenon of paedophile hunter groups, have issued guidance to their officers as to how to respond to that. And from these documents, it is quite apparent that the overriding duty is to respond to any report of an identified person who may pose a sexual risk to children. The risks, the activities, the undesirability of the activities of these groups is set out in the 2019 responding to and investigating reports from online child abuse activist groups. Starting at paragraph 2, it's quoted at length in my submissions. Your Lordships will find it at core volume pages 2097 and following pages. So they will always respond when information is received to suggest a young child is at risk. And at page 2102, your Lordships will see that the guidance stresses that the usual high standards of investigation and reporting to the Procurator Fiscal are required in such cases, regardless of the source of evidence. as the prosecutorial test and the evidential burden is the same in these cases as in any other type of case. And of course, the police will, by virtue of paragraph 10.1, if they needed any clarification, that where there is evidence that the group or individuals themselves may have committed criminal offences in carrying out their activities, this should be investigated. It's established whether there's a sufficiency of evidence and should be reported to the prosecutor in the usual way. And that I may point out and really stress at this point, my lord, that the decoys and groups are as liable to criminal prosecution as those against whom they or from whom they obtain evidence. The consistent and fair application of the law is how the police and the prosecutor approach these matters. That is not to say that they do not recognise the phenomenon of PH groups, their methods. They are not aware of the controversy that they generate in some quarters, that they are unaware of the tension between their activities and the police, or of the challenges that they may pose in certain respects to the criminal justice system. But the prosecutor, the police, and indeed the criminal law and the courts are well equipped to take decisions as regards prosecution and the conduct of trials, notwithstanding all of these factors unique to the groups. The decision making by the prosecution service is, as your lordships may be aware, based on a prosecution code, which is has the benefit of a good deal of simplicity, but also flexibility. And the first question a prosecutor will ask when receiving a report from the police involving evidence from a PH group is there sufficient credible and reliable evidence of a crime committed by the accused? And if there is, the prosecutor will then go on to consider what action is in the public interest. Now, the code sets out factors which may be, depending on the circumstances of the particular case, be relevant in determining what action is in the public interest. These include, among other things, the nature and gravity of the offence, the impact of the offence on any victims or witnesses, the age, background and circumstances of the accused, the motive for the crime, and the risk of further offending. And this may be, of course, informed in terms of the public interest decision by the existence of analogous previous convictions. Because in these circumstances, my lord, for the nature of the offences with which we are dealing, there are positive obligations which entail an effective police investigation and indeed prosecution. And that balance is seen in the case of KU against Finland, which is at core volume page 1616. And if I may take your lordships to page 1627, paragraph 42, this was a case of online abuse in a form of a 12-year-old child, in the sense that he was made the subject of an advertisement of a sexual nature on an internet dating site. and the identity of the person who had placed that advert could not be obtained due to the legislation in place at the time. At paragraph 42, the court reiterated that although the object of Article 8 is essentially to protect the individual against arbitrary interference by public authorities, it does not merely compel the state to abstain from such interference. In addition to this primarily negative undertaking, there may be positive obligations inherent in an effective respect for private or family life. And the court considered at paragraph 45 that while this case might not attain the seriousness of X and Y against the Netherlands, of the case of the rape of the handicapped girl, the court could not regard it as trivial. And page 1628, the end of paragraph 46, the court notes that it has not excluded the possibility that the state's positive obligations under Article 8 to safeguard the individual's physical or moral integrity may extend to questions relating to the effectiveness of a criminal investigation, even where the criminal liability of agents of the state is not at issue. So the classic positive obligation. For the court, states have a positive obligation inherent in Article 8 of the Convention to criminalise offences against the person, including attempts, such as we have here, and to reinforce the deterrent effect of criminalisation by applying criminal law provisions in practice through effective investigation and prosecution. Where the physical and moral welfare of a child is threatened, such injunction assumes even greater importance. The court recalls in this connection that sexual abuse is unquestionably an abhorrent type of wrongdoing with debilitating effects on its victims. Children and other vulnerable individuals are entitled to state protection in the form of effective deterrence from such grave types of interference. And in concluding, page 1629, paragraph 49, the court considered that an effective investigation could never be launched because of an overriding requirement of confidentiality. Although freedom of expression and confidentiality of communications are primary considerations, and users of telecommunications and internet services must have a guarantee that their own privacy and freedom of expression will be respected, such guarantee cannot be absolute and must yield on occasion to other legitimate imperatives, such as the prevention of disorder or crime, or the protection of the rights and freedoms of others. Without prejudice to the question whether the conduct of the person who placed the offending advertisement on the internet can attract the protection of Articles 8 and 10, having regard to its reprehensible nature, it is nonetheless the task of the legislator to provide the framework for reconciling the various claims which compete for protection in this context. Now, my lords, I do say that no Article 8 right to respect for private life or indeed correspondence is live in this case. But KU illustrates perhaps a modern expression in relation to online communications of the positive obligation upon states to have in place really effective criminal law provisions. And I would suggest an obligation on prosecutors, where there is sufficient evidence and in the public interest, to take proceedings. If the appellant is right, my lords, then the prosecutor should issue. My Lord Hodge.
KU seems to suggest, and that's not surprising, that there may be positive obligations on the state in this context by virtue of Article 8. Would that not suggest, therefore, that Article 8 may be engaged, and that the better focus is to say, has any Article 8 right of the appellant been interfered with? Because it seems to me that is the principal focus of this appeal. We may be, for certain purposes, for example, positive obligations in the territory of Article 8, and therefore, to that extent, it's engaged. And the question is the person's right interfered with?
That may be, and I'm perfectly happy and willing to approach it on that basis. But there is an overlap. There can be an overlap between engagement and justification, as I think Lord Tolson discussed in Reg JR.
Yes, the reason I asked this was the questions, the issues raised by the High Court. Issue 1, I think, spoke about interference rather than engagement, and we've drifted into arguments about engagement.
Well, yes, I have to say it has been slightly challenging in precisely identifying what the two issues relate to. On one reading, they amount to very much the same thing. I think parties chose to approach it on the basis of engagement.
I just wanted to raise the point with you because it seems to me that the question focused by the High Court in issue 1 was the correct question. Thank you.
Thank you, my lord. Thank you. So in terms of context and background to the prosecutor's use of evidence and taking proceedings, I do draw the court's attention to the domestic law duties and the positive obligations in this area, which operate to prevent failures to prosecute, failures to present the case to the court, failures to use the evidence where the domestic legal structures allow that. The prosecution policy, as the Dean has mentioned, in Scotland has recognised the existence of PH groups and has ultimately explained that each case will depend on its own facts and circumstances, and that really is the criticism of the appellant, but the rationale of the respondent is that law and convention obligations require these cases to be assessed on a case-by-case basis and not prejudged or declined on a class basis. And I do again stress, my lords, in terms of the in cahoots or a systemic engagement with these groups, where there is sufficient evidence in its public interest to prosecute the PH group members themselves, then they will be and have been and will continue to be subject to criminal prosecution. My lords, the issue of the second issue and the question of interference being in accordance with law or otherwise justified, excuse me, is articulated by the appellant or depends on this suggestion that the police and the Crown are circumventing and avoiding the requirements of the regulatory scheme. There is no basis on which the retrospective imputation of their acts to the police can be justified in fact or in terms of the legislative scheme. The self-tasking of the decoys is just that, self-tasking. And in cases where the evidence is then reported to the police, there can be no question of retrospective responsibility or retrospective authorization or retrospective responsibility. But it's, even if, of course, within the scheme, the authorization of a CHIS will render that activity in accordance with the law or lawful for all purposes in terms of Section 5, but of course the opposite is not the case, and it will not necessarily be unlawful by virtue of the general savings provision at Section 30. The High Court dealt with this shortly and without any difficulty at paragraph 52 and 53 of its judgment, at page 180 of the High Court's opinion. And I can do no better than to follow that conclusion. I mean, RIPSA is intended to achieve what its short title suggests. It's designed to regulate investigatory powers introduced in the Beta Dicta, notably in Malone, with which your lordships will be aware. If the conduct is authorised, it becomes lawful for all purposes. The authorisation will protect the relevant authority, the relevant person from civil liability. That's Section 5 of RIPSA. That is not to say that conduct which is not authorised is thereby unlawful. Depending on the circumstances, there may or may not be a contravention of Article 8 and the common law principle of fairness if an activity which required authorisation was not authorised or the conduct fell outside the terms of the authorisation. And the court goes on to acknowledge that RIPSA may apply where a private individual is being directed or has been engaged by a public authority, for example, in the case of or in a self-tasking, which is under paragraph 226. There was no element of direction or engagement of the decoy. No RIPSA authorisation was required, nor was a scheme of legislation required where private individuals who are the subject of common law were involved. There could have been no application for authorisation because the police were unaware of their decoy's activities until after the appellant's allegedly criminal activities had been, to all intents and purposes, completed and recorded. Even if the police had been aware, they were not in a position to control these activities. Paedophile hunter groups are not law enforcement agencies or agents whose activities for the purposes of RIPSA fall to be regarded as those of a public authority. On the contrary, they are private enterprises with no investigatory powers whatsoever. And the issue of the repeated conduct of Atch's Dean of Faculty refers to the business, the systemic receipt of these reports by the Crown. In the case of R against Walters, at core volume 1182, a decision of which the High Court approved, Justice Langstaff said at the end of paragraph 34, explaining why the fact that where a local or public authority proposes to use a CHIS, that authority may secure that a relevant person within the meaning of Section 30 of the Act grants authorisation, thereby relieving the CHIS of any liability to which he might otherwise potentially be subject, cannot, in my opinion, affect the situation where the authority does not seek the use of the CHIS in the first place. Repeated conduct by a CHIS, which is repeatedly productive of evidence then handed to the police, does not have the consequence that the police are to be said to have used or conducted it. Any use in a situation such as that in the present case is retrospective, not prospective. It is the latter to which the scheme of authorisation applies. And my lords, I say that has to be right. To suggest otherwise is to require the impossible. There's no basis upon which the contention that the police are seeking to circumvent the requirements of RIPSA can be justified. Where the police, as the relevant public authority, are unaware of a relationship between private individuals, there can be no requirement to consider authorisation under the relevant Act. That would simply be an impossibility. At the same time, upon receipt of those communications, which result from that relationship communications, which amount to evidence of a serious criminal offence, the police cannot ignore such evidence simply because it comes from a PH group, nor indeed, as I've suggested, my lords, can the prosecutor avert his eyes and refuse to entertain it. I confess, my lords, to being a little confused about the virtue testing point. The appellant accepts that PH groups are not public authorities, that the decoy was not authorised or tasked by the police to act as he did. The appellant accepts that the particular actions of the decoy do not amount to entrapment and would not have amounted to entrapment had they been carried out by the police. And I think that is again not surprising when one looks at the communications. Nevertheless, notwithstanding that, my lords, the appellant contends that the actions of the decoy amounted to virtue testing of people not being suspected of being engaged in any criminal activity. And that being so, the court should proceed on the basis that a CHIS authorisation having been sought for under RIPSA for such activity, it would not have been granted. Now, again, I do struggle to see the relevance of this to the issues, to the compatibility issues, but it has been raised. And if entrapment is not an issue, I fail to understand why virtue testing is. And in any event, is not the proper characterization of the type of activity engaged in by these individuals, or indeed police officers acting undercover. The High Court of Justiciary, and indeed many other documents, cases involving OCAGs and PH groups, make it clear that they do target websites, chat rooms, whatever, in order to lure the potential paedophiles by the online, the profile of a child. there was a finding in fact to that effect in this case, and that is in common with many of the authorities in relation to such groups, such as TL as one example. The associated contention that an authorisation for a CHIS to act in this way would never be granted is also untenable, whether it's relevant or not, whether it's speculative speculation or not. It is untenable by the information from the police that they have in the last 5 years conducted covert law enforcement activity or type analogous to that typically undertaken by PH groups. This kind of online activity, covert activity, is specifically envisaged in the Scottish RIPSA code. That can be found at core volume page 442 at paragraph 4.7. And the case of HMA against IP from 2017, that's at core volume page 757. That gives a relatively recent example of the use, not very satisfactory use, but the use of a CHIS in the investigation of suspected online sexual offending. So, my lords, the question of whether RIPSA was engaged is simply nothing to the point, in my respectful submission, in relation to the issues for your lordship's consideration.
Well, in any event, I'm inclined to doubt whether it's within our jurisdiction. We have the High Court's conclusions, which you took us to in paragraphs 52 and 53,
Indeed.
and they obviously took the view that RIPSA was not engaged here. We have no jurisdiction to review the decision on the application of domestic legislation.
It is a pillar of their argument that the interference with his Article 8 rights, as he contends he has, it is a pillar of that argument that the circumvention of RIPSA provides some justification, but it is an argument which I have some difficulty with, and I do say that it is simply irrelevant.
Well, the court did say at the end of paragraph 52 that that there might be, so depending on the circumstances, there may or may not be a contravention of Article 8 and the common law principle of fairness if an activity which required authorization was not authorized.
Yes.
So equally, the common law, I dare say, would apply if there was a deliberate circumvention of the legislation. And Article 8 might also, but yes, the point's not developed by the court because it didn't arise on its findings as to the applicability of RIPSA.
Now, my lords, that takes me to the nearly final chapter of my submissions, and it is to touch briefly on the issue of Article 8 and Article 6 in the context of this appeal, these issues, and the criminal trial, because it's well established in both convention and domestic jurisprudence that any question as to the fairness of the use of evidence with which these issues are squarely concerned is one properly arising under Article 6 rather than Article 8 ECHR. And there are a number of authorities to that effect. Probably most notably Kinloch, the HMA 2013, which is to be found at core volume page 582. And Lord Hope of Craighead's decisions in the matter. And so at paragraph 17, which is core volume page 582, as I say, my lord, this was the case of the man carrying, I think it was drugs to and from, carrying bags to and from in a public place.
It was money laundering.
Money laundering. That's correct, my lord. And as I say, paragraph 17, Lord Hope made the point, it should be noted too that the issues relating to the lawfulness of an interference with private life must be distinguished from those about the fairness of the use of evidence in a trial. The tests as to whether there was a breach of these two articles are different, as are the remedies if they are held to have been breached. So the way the evidence was obtained may infringe Article 8, yet the leading of that evidence might be held not to be incompatible with Article 6. That followed the earlier, significantly earlier case of McGibbon, the HMA in Scotland, where that is 2004 justiciary cases, core volume page 822, where Lord Justice Clark Gill made it clear at paragraph 21, which is the page I've referred you to, the protected interests under Articles 6 and 8 are separate and distinct, and the nature and scope of an individual's rights under those articles are determined by different criteria. While the method of obtaining evidence may infringe Article 8, the leading of it may nonetheless not infringe Article 6. And a similar distinction is recognised in the common law of Scotland. The underlying principle is that of fairness. And there's a legion of authority, my lords, to the same effect from the European Court's perspective. We have Perry, the UK, and Can, the UK, core volume page 1815 at para 34. Again, even if the evidence was obtained in breach of Article 8, that does not give rise to the remedy that the evidence should be excluded. The court in Can held that the admissibility of evidence is not a convention matter, but a matter for the domestic courts. Domestic law allows the accused to challenge that evidence, that admissibility, and the admission of evidence obtained in breach of Article 8 will only amount to a breach of Article 6 if it can be shown to have been productive of an unfair trial as a whole. So, what first observation, my lords, even if contrary to all of my submissions, this court was to find that some aspect of the procedure in cases involving PH groups and the use of evidence by public prosecutor in particular, that constituted a breach of an individual's Article 8 rights in some way, that would not result in the evidence obtained being rendered inadmissible. in a criminal trial. And of course, it's noted in the present appeal, the High Court addressed that point, and at paragraph 51, so the paragraph immediately before the dealing with RIPSA, the Lord Justice General stated at, as I say, paragraph 51, whether or not there was an interference with the appellant's Article 8 right to a private life, the question of whether there was or will inevitably be a breach of Article 6 will depend upon consideration of all the circumstances in order to determine whether the proceedings as a whole have been fair, referring to each.
Solicitor General, I'm afraid I'm going to have to interrupt you because I see the time.
Oh, right. Yes, of course.
So
sorry.
can we, is that a point at which we might adjourn?
Yes, indeed, my lord.
We'll sit again at 2 o'clock.
Very well. Thank you.